Hi guys, my name is Lista Nyansanza, a student at Great Zimbabwe University. Today we want to present on jurisprudence, mainly focusing on justice. I'll be presenting with my colleagues Taro Masiandima, Langton Madima and Princess Shaita. So we'll first define what jurisprudence is, then go to what justice is, the development of justice, the requirements of justice, the principles of justice, and move on to the theories of justice. So, what do we understand by the word jurisprudence? Jurisprudence is the study of the science of law. It is the study of law which penetrates to the theory and philosophy of law as a discipline. It is the study of law that does not only extend to the statutory books, but to when and how the laws were promulgated, the development of the law, and the concept of justice. It attempts to answer the question, what is law? According to Fitzgerald, jurisprudence is both the philosophy of law and a reflective study of rules which form the basis of concrete legal problems. The Latin term juris means law, whereas prudentia means knowledge. Jurisprudence focuses on the definition of law, the relationship between law and morality, the relationship between law and the religion, the function of the law in the society, and the relationship between law and justice. So we'll be focusing on the relationship between justice. Moving on to our core presentation, justice. We'll first define what justice is. In view of the main function of the law, that is creating and enforcing rights, it always makes sense to ask where law is just and where it is not, to demand reform. The word justice is derived from the Latin term jus, which means to bind to contract. Others say it's nothing but just being fair. From a law point of view, it's a process using laws to judge and punish crimes and criminals fairly. Justice is the result of fair and proper administration of law. It stands for just conduct, fairness, or exercise of authority and maintenance of rights. Justice also relates to the substance of the law and is an external yardstick to use to measure if law is just, fair, or not. Justice has the following implications. It requires a just state of affairs. It is aligned to the condition of morality. It carries the sense of proper distribution of favor and losses. What does justice require? According to utilitarians, justice requires the maximization of the total or average welfare across all relevant individuals. It may require sacrifice of some sort for the good of others, so long as everyone's good is taken impartially into account. In other words, justice requires that the community help one another such that equality and fairness is achieved. Justice also requires fairness. It requires proper proportion. It requires equity. It requires democracy. It also requires moral freedom and social and political freedom.
Okay, so my colleague previously introduced the topic and introduced us. So I'm Taro Masiandima and I'll be taking you through principles of justice. So John Rawls proposed principles of justice that are self-interested and rational persons might pick. So he contends that the most rational choice for the parties in the original position are two principles of justice. The first guarantees the equal basis, the rights and liberties needed to secure fundamental interests of free and equal citizens and to pursue a wide range of conceptions. So the second principle provides fair equality of educational and employment opportunities, enabling all to fairly compete for powers and positions of office, and it secures for all a guaranteed minimum of all purpose, including income and wealth. So that individuals need to pursue their interest and to maintain their self-respect as free and equal persons. Okay, so the first principle is equal liberty. So the first concept of justice to emerge from the initial stance in this principle of equal liberty. According to Rawls, it asserts that all citizens have an equal right to essential freedoms which include freedom of conscience, speech, association, and democratic rights. Right? So, according to Rouse, personal property is one fundamental right that individuals should enjoy and that the government cannot violate or modify. However, he did not include an absolute right to limitless personal property as part of the fundamental rights that individuals should enjoy. So we are moving on to the second principle, which is equality. According to the equality principle, economic concepts should be organized so that they satisfy two conditions. The poorest members of the society should be given more advantages, that's the first one. Second, economic disparities should be structured such that no person, regardless of race, gender, or socioeconomic background, is barred from holding any job or office. Rouse stated that everyone in the society should be afforded the same opportunities and chances as everyone else to equivalent natural attitude.
Alright, moving on to the theories of justice. We'll start by the social theory of justice. This concept of the social theory of justice first emerged in the 19th century as there were wide disparities in wealth and social standing. Historically, the idea of social justice was that all people should have equal access to wealth, health, well-being, privileges, and opportunities regardless of their legal, political, economic, or other circumstances. It advocated for equal distribution of resources. The social theory of justice may be thought as the common good through the equalization of goods or services. In the modern practice, social justice revolves around favoring or punishing different groups of the population regardless of any given individual choices or actions based on value judgments regarding historical events, current conditions, and group relations. So, a value judgment is an opinion based on one's principles and beliefs and not facts that can be proved or checked. The state is restricted from discriminating against citizens based on their nationality, race, color, tribe, place of birth, ethnic or social origin, sex, gender, marital status, as demonstrated in the Constitution of Zimbabwe on Section 56. Social justice is about equality and equal rights among citizens. Aristotle states that injustices arise when equals are treated unequally and also when unequals are treated equally. In the Greaterman's case, the court upheld the non-discrimination clause where they applied reasonable differentiation and equal protection of the law. In this case, a group of employees had been terminated on notice by their employers without any compensation in reaction to the Zuma Petroleum case. There was a case of unfair labor practices and inequality. By allowing the law to apply in retrospect, the judges upheld justice as they upheld the common good. The law did not treat the unequal as equal, thus upholding the principle of justice. One would therefore conclude that justice seeks the fair or equal distribution of resources and the just application of the law among the citizens. So now I'm moving on to domestic justice. Under domestic justice, we ask certain questions. Is the state entitled to prevent adults from performing actions that do not directly harm other people in the sense of actively preventing them from living as they fit? Does that not affect the concept of justice by punishing someone because of their personal judgment that does not affect anyone else? Justice requires that the state outlaw killing, kidnapping, assaulting, enslaving, fraud, and other crimes as these actions directly affect other people's well-being and lifestyle. The question, however, remains, should justice regulate the actions that do not directly harm other people? For example, smoking daga, engaging in prostitution, lesbianism, gay sex, and many more. Can the state punish competent adults for performing actions like those in the name of justice? Liberalists believe that it is wrong for the state to punish and prevent citizens from performing actions that do not substantially impair the ability of other citizens to live as they please. Law should not be administered to satisfy value judgments. It should be promulgated for order in the communities. This therefore leads one to the theory that law and morality do not have a relationship. Liberals believe that competent adults should have the liberty to engage in actions that might be self-destructive, obscene, or degrading, as long as the actions directly affect no person besides the person engaging in the actions. It should not be just if the actions are punished or discouraged with paying taxes, even if the society finds the actions offensive, imprudent, or immoral. As moral principles are of individual and relative application, they must be applied with reference to circumstances and individuals. Thus, in the event that a person does an immoral act that would not affect anyone, they should not be punished or taxed. This is different from legal rules that should deal with actions that affect the well-being of the society and are of absolute application. The state should not promote one religion or cultural way over the other. Morality should therefore not be used to deter people from doing actions or things they enjoy, which do not harm others in the process, as humans are intelligible to play, aesthetic pleasure, and freedom. Justice is the state recognizing these rights. It calls for equal treatment. In Bowers versus Hardwick case, a case of sodomy, the judges upheld justice. It was stated that no matter how uncomfortable a certain group may make the majority, mere public intolerance or animus cannot constitutionally justify the deprivation of a person's physical liberty and rights to privacy.
So we are moving on to economic justice. So economic justice is a component of social justice and welfare economics. It is a set of moral and ethical principles for building economic institutions, where the ultimate goal is to create an opportunity for each person to establish a sufficient material foundation upon which to have a dignified, productive, and creative life. Economic justice is the idea that the economy will be more successful if it is fair, and that prosperity and justice go hand in hand rather than in opposition to one another. The goal is to achieve opportunities for all to thrive. Universal basic income, income equality by gender and race, equal opportunity, equal for employment and credit, and allowing all to reach their full potential are key tenets of economic justice. Okay, so we are moving on to economics and normative jurisprudence. So though analytically incomplete, economic analysis models the actual results of legal institutions better than any other theory. This does not entail, however, that law ought to be consciously used for such an aim. Might not be better used to consider issues related to justice, duty, and the like. Advocates of law and economics have argued against such a conclusion. The arguments usually are of two types. First, it is claimed that meanings of words such as justice or duty are so vague and in dispute that the use of such concepts for a basis of judicial decisions offers no guidance whatsoever. It is argued that while such concepts are unhelpfully complex, the tools of economics analysis and the concept of economic efficiency are sufficiently clear to provide the judge a solid and predictable basis of decision. Law is better able to decide according to efficiency rather than justice or due to limitations of institutional competence. This might be so if issues of justice are so complex as to involve information that courts are structurally unable to process. Second, it has been argued that because the paradigm case of justice is the freely entered into contract. Second, it has been argued that because the paradigm case of justice is the freely entered into contract, law is best seen as a tool to optimize contractual arrangements. If this is so, then where law can help is in situations where transactions costs are so high so as to prohibit efficient contractual relationships. Posner argues that law can encourage economic efficiency by assigning property rights to those parties who have been secured through market exchange if transaction costs were lower. In other words, law should bring about locations that mimic the results of a properly functioning market. In addition, advocates of economic analysis of law make a claim that other jurisprudential traditions seem to be unable to, that the analytics tools offered by law and economics have encouraged the further creation of other productive areas for analyzing law. Posner, 1998.
Hello guys, as once mentioned by my preceding colleagues, my name is Langton and I'm presenting on the topic of justice and politics, justice in the context of politics. So yeah, in order for one to thoroughly understand the relationship between justice and politics, a brief test in understanding the meaning of both terms is necessary. Politics, according to the Merriam-Webster dictionary, it relates to governance, while the Marxist theories seem to imply that politics is the struggle for power between social classes. Therefore, political justice seeks to balance the scales of political power between the strong and the weak in an attempt to bring out the tenets of fairness and equality. Justice, on the other hand, according to Professor L. Maduku in his book Introduction to Law, is fairness in a broader sense. He aligns justice with the naturalist school of thought that claims that laws without tenets of morality and fairness are not just and good laws, and for that reason are not laws at all. This definition can be seen manifesting in the Greaterman's case, in which a more naturalistic approach can be seen manifesting in the sense that a decision was arrived that employees who had been unfairly dismissed prior to an amendment of the law had to be compensated, even if the compensation would mean that the law was being... He aligns justice with the natural school of thought that claims that laws without tenets of morality and fairness are not laws, and they are not just laws, and for that reason should not be regarded as such. This definition can be seen manifesting in the Greaterman's case, in which a more naturalistic approach was taken to arrive at the decision that employees who had been unfairly dismissed prior to an amendment of the law had to be compensated, even if the compensation would mean that the law was being applied in a retroactive manner for the sake of achieving fairness. Political justice is therefore a term of distinction. As such, its meaning varies according to the different aspects of justice that it is used to identify. This particular chapter of the presentation discusses 4 ways in which the term may be used. The first one being to characterize the principles that govern a distinctly political sphere of distributive justice. The second one being to point out to a distinctly political way of arriving at principles of distributive justice. And thirdly, to describe the departures from the ordinary forms of criminal justice that are required by political trials. Then lastly, to characterize the distinctive forms of justice that emerge within politics as contrasted with other forms of community justice. The presentation is an appendage of the topics already discussed by my fellow colleagues. Thus, it comes to examine political justice from a jurisprudential view. For that reason, the 4 ways in which political justice is seen ought to be concluded as follows: fairness, proper proportion, equality, equity, democracy, moral freedom, social and political freedom. One of the reasons why the issue of political justice in conclusion ought to be discussed is the belief by Plato that rational and political order leads to the harmonious unity of society and allows all the people in a society to pursue happiness but not at the expense of others. Thank you.